Welcome, everybody. I'm John Evangelakis, the president of Harvard Alumni for Free Speech. Harvard Alumni for Free Speech is a nonpartisan, not-for-profit group dedicated to promoting free speech, academic freedom, and viewpoint diversity within the Harvard-Radcliffe community. Today, we want to talk to you about the ongoing litigation between Harvard University and the federal government. You no doubt have been following what's been going on in the news. The federal government has frozen over $2 billion worth of contracts to Harvard University, and has also tried to shut down giving visas to foreign students who are attending Harvard University. In response, Harvard University has sued the federal government, and we're in the midst of this litigation, fast moving at this point. We thought it would be interesting for you to get an overview of what's going on. And I'm joined here today by my friend, Phil Augusti, another one of the founders of Harvard Alumni for Free Speech. Phil is a retired litigation partner. He worked at the highly regarded Washington, D.C. firm Steptoe & Johnson. He is a frequent legal commentator, and he has reviewed all the pleadings to date. And he's going to provide us an overview as to what this litigation is about and what the principal arguments are of the two sides. So Phil, thank you for being here. I'll turn the floor over to you, and why don't you tell us what this is all about?
Thanks, John. Very happy to do so. So essentially, Harvard is involved in two lawsuits. There is one lawsuit that has to do with the immigration actions that the Trump administration has taken. And as John alluded to, that's the Trump administration first revoked Harvard's ability to admit foreign students. And when that was preliminarily enjoined, then the president issued a presidential proclamation trying to keep out all aliens that were going to attend Harvard. And that was enjoined as well. That's one lawsuit. The second lawsuit, and the one that we'll probably spend the great bulk of our time today on, is a lawsuit relating to the freezing of all of Harvard's federal grants. And that lawsuit, essentially, as John said, was triggered by Harvard's rejection of certain actions that I'll talk about in a minute. There's been no rulings in that lawsuit other than very preliminary procedural rulings. And the case is currently being briefed, and there will be a hearing on July 21. So that will be probably what I will be talking the most about. Just real briefly on the immigration suits, Harvard is undefeated, if you will. They've won 2 TROs. They've won, and those have both been extended into preliminary injunctions, which of course means that now the government can appeal to appellate courts. I will say, and I'm happy to answer any questions that John might have on those suits. I will say that Harvard has a very strong statutory argument, and it has strong jurisdictional position. So they do not appear to be as vulnerable in that area. On the grants freeze lawsuit, on the other hand, is a bit more interesting. So let me just talk real briefly about the facts that sort of triggered everything, and then I'll jump right into the parties' arguments. The facts are not all that complicated. On April 11, the Trump administration sent a letter to Harvard, which substantially demanded that Harvard turn over much of its admissions process, its hiring of professors process, and called for monitoring of certain Harvard students' views, all with the objective of achieving what the administration thought would be a better balance of viewpoints in the administration's views. The Harvard very promptly rejected that letter and filed a lawsuit. That lawsuit was filed by a series of very adverse administration actions. First, of course, all federal grants were frozen. Second, the Trump administration recommended to the General Counsel of the Internal Revenue Service that it revoke Harvard's nonprofit status. It then took the immigration actions to which I referred, the revocation of their ability to certify students and the presidential proclamation against students coming to the US to attend Harvard. In each of those cases, I will say that when we can talk further about what the rationales were, but all of the rationales for the actions did not refer back to the April 11 letter, but rather referred to, in the case of grant freezing, anti-Semitism. In the case of the immigration actions, some alleged good relations that Harvard had with the Chinese Communist Party, etc. What are the claims? Harvard's lawsuit, both lawsuits actually, assert that the United States has basically violated its constitutional rights. And it basically bases those on two types of theories. One of them is a theory of retaliation. Under well-established law, the government can't retaliate against someone for its views, its political views. And under another stream of precedent, the government can't place conditions that are based upon a person's views before that person can get government benefits. And there are other constitutional claims that are very much along those lines. As I said, the law is very well established in these areas, and Harvard would be, assuming the facts that they've alleged, in a strong position. The government actually hasn't challenged the theories so much because, as I say, the theories are relatively unchallengeable. What the government's done instead in the constitutional area is that it's challenged the facts. It says that the April 11 letter was not a series of demands. It notes that they were not that letter was not final agency action, and rather it characterizes the letter as a settlement offer. And the government points to good law that says that once a party rejects a settlement offer becomes a nullity. And so the strategy of the government is basically to eliminate the April 11 letter as a factor and to have the government actions judged on their own merits. It's unlikely, I think, that Judge Burroughs, who's the district court judge here, the trial judge, and the person that first gets to rule on these issues, is going to accept the government's position. The government's the truth is that the April 11 letter, while a settlement offer, can certainly be considered under the rules of evidence for the government's position. And there really is no other demand that the government made prior to taking these various actions. There was no attempt to seek voluntary compliance from Harvard. There is essentially, a strong factual basis for Judge Burroughs' finding that indeed the April 11 letter was a demand and that Harvard is being punished for not complying with those demands. And I would add that Judge Burroughs has found in the preliminary injunction order that related to the immigration cases, which, as I said, she's already issued, that Harvard had a likelihood of success on the merits on the constitutional issues. So it seems very unlikely that Judge Burroughs is going to change her mind when she gets to the grant freeze case. And so I think that on that score, Harvard is in very, very strong shape indeed. To the extent that Harvard has vulnerability, it's on appeal. And that's because of the nature. This is not at all a criticism of the Harvard strategy, but rather a necessary consequence of getting a quick final judgment through summary judgment is that you have to go through summary judgment, and summary judgment has very high standards for findings of fact. The parties have to show that there's no genuine dispute of fact as to any material fact. And of course, there's nothing more material than the April 11 letter, which is the series of demands on which Harvard hinges its entire constitutional argument. Um, as I said, Judge Burroughs is unlikely to accept that factual argument, but because it's on summary judgment and because there will be no live testimony in front of Judge Burroughs, that those findings that she makes are not entitled to any deference. And so a court of appeals, including the Supreme Court, could easily say, the government has presented a factual dispute. They have cited to the face of the documents, and this raises a factual issue that you really can't resolve on summary judgment. You've got to listen to testimony before this can happen. And so while the Harvard constitutional claims, as I've said, are extremely strong and very likely to win at the trial level, there is substantial amount of vulnerability on appeal, particularly if a majority of the court is inclined not to want to reach those issues. I'll turn then to the statutory claims because Harvard also asserts statutory claims. The first one of them is Title VI, which is the normal procedure under which a university is denied um, government benefits on the basis of discrimination. And I might say that there's virtually no record of any university ever having been denied benefits in the way that Harvard has been denied benefits on the basis of discrimination. Uh, so basically, again, the government, the Harvard points out that the procedural requirements for a Title VI nullification of federal benefits has not been made. There are certain specific requirements that I can detail if it's interesting, but things like, for example, you need to have sought voluntary compliance from Harvard. You need to file a written report and put it in front of Congress for 30 days. These things, there are procedural requirements that have unquestionably not been followed by the federal government before taking its action. And so the government, predictably, while making a little bit of a hand wave at the fact that, well, they've done things that are effectively provide similar protection, their principal argument is actually that Title VI doesn't apply. And their argument is that Title VI doesn't apply because this is a federal grant and the government unquestionably has the right to terminate any federal grant that it wants to. Typically, what would happen if the government terminates a grant on the basis of policy is that it then has to pay something to the grantee on the basis of whatever the contract requires it to be paid for the termination. But it's clear that you typically can kill a grant for convenience or for a change in policy. The difficulty here for the government is that the notice that it sent to Harvard said that it was terminating it for anti-Semitism. And that is a discriminatory ground. Title VI clearly sets forth which was enacted by Congress, clearly sets forth a required procedural set of steps that you have to take if you're going to terminate on that basis, and they haven't done it. The argument that the government is advancing in this case actually would effectively make Title VI surplusage. That basically, it's one route, but it's not a necessary route at all. And that is something that this textualist majority on the Supreme Court is unlikely to accept. That runs in the face of statutory construction canons that the textualists care deeply about. So I would say that on the statutory, and that statutory ground is perhaps the strongest ground that Harvard has in terms of reaching a result. I suppose if one is looking for negatives associated with that approach, is that it's that the government can always remedy what it's done procedurally wrong. So if courts were to decide that the government did not had to comply with Title VI and did not do so, it could simply start at the beginning and then go ahead and have the necessary hearings, have the necessary report, and at the end of some time, and we can all disagree as to how long that would be, the government would be back at the same place. It would at least be a process of several months before it could do that. And meanwhile, assuming that this court has jurisdiction, payments would have to be made. The final ground I'll treat very briefly, which is the Administrative Procedure Act. It also has requirements for government to act. Those requirements clearly have not been satisfied in this case. So if the APA applies, uh, the government would also lose on that ground as well. But predictably, the government says that the APA doesn't apply, and it's got a pretty decent basis for that, and that brings us to what is the biggest problem for Harvard in this case, and that is what is commonly referred to as the Tucker Act. It's officially called Government Contracts Compliance Act, but everyone refers to it as the Tucker Act, and I will here. Essentially, the Tucker Act says that Congress has given exclusive, that means no one else can hear cases in the first instance to anyone other than the Court of Federal Claims in Washington, D.C., when you are suing on a contract against the federal government. And so, and just to give you a little bit more on a little bit bigger primer on the Tucker Act, essentially, it doesn't matter what arguments you make. You can say that the government violated the contract because of unconstitutional actions. The government violated the contract because of regulatory regulations it didn't follow. Whatever the argument is, the law seems to be pretty clear that you have to that when you're actually suing for money damages under a contract, that you have to be back in the Court of Federal Claims. And let me tell you why that matters so much. The Congress has also been very clear that when you sue the federal government under a contract, and by the way, a grant is clearly under the law a contract. Okay, so I've referred to contracts. Grants are contracts. Then basically the federal government does not have to pay a dime in the dispute until after the litigation is completely over. So if the case was transferred to the Court of Federal Claims, not only would they have a less favorable court, but also, and more importantly, Harvard would have to wait for 2-3 years before it would have any judgment that it could enforce against the government. Meanwhile, of course, it would have to do without the funding for those grants. So that's the importance of it. Um, I will say that one of the things that makes this particularly of concern to Harvard is that the Supreme Court has very recently ruled on a case very similar to this in an adverse way to Harvard. In the case of the Department of Education against California, which was just decided in early April, yeah, that's 2 months ago, six members of the Supreme Court said, just on the facts, basically that was a case in which a series of academic institutions were suing the government for failing to fund their grants, and they were arguing that this was inconsistent with statutes that they weren't funding under the grants. And they made some of the arguments that you would expect Harvard to make here. The six members of the court flatly rejected that argument and expressly said that this belongs in front of the Court of Federal Claims under the Tucker Act. So that's got to be of concern to Harvard. Now, what's Harvard got to say about this very difficult jurisdictional problem? Um, Essentially, they have not had a chance to give their full response. That will come on June 30th. But they, both in the complaint and in their moving papers, they've sort of indicated where they're going. They've taken the position and say, hey, we are not asking for money damages. We're calling for an injunction. The government, of course, as other litigants have in this context, point out, well, the injunction that you're seeking is for the government to pay money under a contract. And so you can't evade the Tucker Act in that way. And they've also, in the more recent motion papers, they've advanced an argument that this is an ultra vires act and that federal courts have equitable jurisdiction. The Court of Federal Claims is an Article II court and does not have equitable jurisdiction. And the government has done something wrong here, so we can remedy that. That argument was also advanced in the DOE versus California case, and the court. I mean, obviously, the court didn't review it in great depth, but it certainly didn't seem to move the Supreme Court. And so, I'm not suggesting you can never. I'm not a prognosticator. I'm a lawyer. But you can never know what the court is going to do, but certainly Harvard would have to be worried about their ability to maintain this lawsuit in light of that litigation. As I said, I wanted to try to wrap this up and give John a chance to come at me. So essentially, that would be about all that I'd have to say. I think that there's much more vulnerability in the grants case than in the immigration case. Um, but of course, the grants case, which involves billions and billions of dollars, is very, very important indeed. So with that, John, have at me.
Bill, thank you so much. That was very well done. Very helpful overview of what's going on. And I take your point on the Tucker Act. It's a serious argument. I think probably the best argument the government has. But the DOE versus California case was not based on constitutional violations, and I think there comes a point where the court, if it wants, and a court can distinguish between a lot of Tucker Act jurisprudence and use of government contract, the use of the government purse to really undermine fundamental constitutional rights. In this case, the government is using the power of the purse to override the First Amendment rights of Harvard and members of the Harvard community. I posit just for your, what you would think about this, but what if the any government administration decided tomorrow, hey, we're just going to cancel the contracts of anyone who happens to be of the other party. You know, I guess today would be Democrats. The Democrats, next time the Democrats win, they can cancel all the Republicans parties' contracts. And it's hard for me to believe that the Supreme Court would say, okay, all of those can only be heard. You know, these massively important cases have to be heard through the Court of Claims in the first instance.
Well, that's a really good point, John, and you lay out a very good hypothetical. I will say this: that there is significant law suggesting that the fact that one of the bases for non-payment of the contract is a constitutional violation does not strip the Court of Federal Claims of its exclusive jurisdiction. That's been stated specifically both by the Supreme Court and the Federal Circuit, I should say, which is the court that reviews Court of Federal Claims cases. So while one might think that, gosh, how can we deny federal district courts the right to hear a constitutional violation? I mean, the answer that I think the government would give is you're not being denied the right to litigate that issue. You just have to do that in the court that has exclusive jurisdiction to deal with different defenses against, or I should say, causes of action based upon a contract or that address what's going to happen in a contract. As for the hypothetical that you raised, it is troubling that you can have I'm not here to judge the facts. Let Judge Burroughs do that. I mean, the fact of the matter is that the string of actions that were taken by the federal government against Harvard do strongly suggest that this was a little bit of an ad hominem attack on an institution for something. It's troubling that you wouldn't be able to go to your local district court to have that kind of thing addressed. It's certainly inconsistent with the ultra vires series of cases to which Harvard is pointed. But I will say that the government is not without weapons here. As the government actually did say in its opposition to the motion and its cross motion, because one thing I should clarify is that the government has moved to dismiss the Harvard case, which would then have to be refiled in the Court of Federal Claims. Basically, it said, look, we're not saying that these constitutional grievances can't be addressed. They just have to be addressed over there. And you know the it's what you the problem is really the legislative problem that the Congress has said that when you're suing the federal government, you got to wait for your money. That's a rule that's been in place for decades. So it's not. So this the kind of unprecedented political nature of this attack makes it points out that perhaps this isn't the best system, but I think that, and I'm not saying that the court's going to come out this way, but I can certainly see that conservative justices that do not necessarily want to stand in the way of whatever the president is doing might well follow the law. This is not a theory that they have to make up. It's a theory that's already there and that it's fairly strong.
No, let me just to push a little bit further on the Tucker Act, and this is sort of a different angle to this issue. It seems to me, and I was sort of want to get your perspective here, that there is a tension or an inconsistency between the Title VI procedures and the Tucker Act. Because if the Tucker Act says that all government contract claims have to go through the Court of Federal Claims, then all of the, not many of the Title VI remediation cases, if there, I guess there weren't many before this, those would all have to go through the Court of Federal Claims if the government is seeking to curtail grants or contracts to an institution in question, right? So but Title VI doesn't provide for exclusive jurisdiction in the Court of Federal Claims. So am I thinking about this right, or how do you reconcile these two statutes?
Well, I think again, John, that's an excellent question. Basically, the Title VI doesn't say anything about jurisdiction. Title VI basically says, "Hey guys, this is how you have to terminate a contract if you're going to terminate it on the basis of discrimination," and a couple of other bases, by the way. And you have to follow these procedures or your termination isn't appropriate. It doesn't really say where you have to litigate it if a university is going to challenge it. And as I said, nobody has ever, one of the things in reading about the Title VI that I was struck by is that Title VI has been used actually by Democratic and Republican administrations in the past, actually more frequently by Democratic administrations, in order to encourage, if you will, universities to adopt some of the policies that the Trump administration is now trying to eliminate. And the process and no university has ever put itself in a position where it is going to be cut off. And so we actually don't really know. As far as I know, there's not really, and maybe we'll see some in the context of the Harvard June 30th brief, but I certainly haven't seen any case that shows where you litigate this Title VI termination, because nobody has ever suggested that you should have a complete death penalty, if you will, to an institution. And it may well be, the logic certainly is that because since it is a grant, or a lot, one way of arguing it from the government side is that you always have to do it in the context of the CFC.
Interesting. So you've laid out the arguments here. Maybe it might be useful for people watching this to let them know what are the next steps, what's going on here, and where do we kind of see this how do we see this resolving itself or ending up?
Well, I think that the next brief is June 30th.
And that's Harvard's reply brief.
It's Harvard's reply brief. Because there has been a cross motion by the government, then actually the government is going to get an opportunity to make a reply to Harvard's opposition to the cross motion. At some point, I believe it's July 7th. Don't quote me on that, but it's in that vicinity. And then there's about a 2-week period for the court to study the briefs, and then the hearing is July 21. And I think July 21, Judge Burroughs has been in all of these cases. Pretty much the orders have come afterwards, but she's pretty much expressed herself clearly at the hearings as to how she's likely to come out. So we may have a sense of what she intends to do on July 21, or she may just take it under advisement. I would say, one of the risks that Harvard faces actually is that Judge Burroughs might well find that she has no jurisdiction. She is very favorably disposed to Harvard, I would say. She's made them winners everything before her. And, of course, she was the judge in the famous fair admissions, students for fair admissions case. And she made very many favorable factual findings for Harvard there. So, people think that she's fairly disposed, but the DOE versus California case was basically reversing an order by one of the people down the hall from her in the District of Massachusetts. So it's not like she's not aware of the Tucker Act issue as being, a significant problem when she may feel that although she doesn't want to, that she has to follow that.
And then after, assuming that the district court finds for Harvard, well, actually, that regardless of whether the decision, and then that'll be followed, but presumably by an appeal to the First Circuit, and that, and then probably through an, certiorari or some kind of appeal to the Supreme Court, unless
Yes.
the case is settled before then.
Yeah, and you could have a settlement before June 30th. That would be a natural thing to do. But yeah, basically, right now, the United States can appeal the preliminary injunction orders with respect to that Judge Burroughs issued recently, including the one she issued last Friday. The opinion actually just came out Monday. Um, and so the government can certainly appeal those to the First Circuit right now. The Supreme Court in these cases has been taking a lot of cases out of turn. Normally, it takes a fairly long time to get certiorari and then to have the court hear something. But in some of these initial cases involving what the Trump administration is trying to do, it has actually expedited cases, particularly when you get in the situation about staying orders. They've been relatively quick to act on stays. Most recently, yesterday, they basically lifted a stay, effectively telegraphing. I should say Monday, they lifted a stay, telegraphing that they're probably going to reverse the decision at some point down the road. So I would actually expect that whichever way this turns out, other than if Judge Burroughs sends it to the Court of Federal Claims, I would expect the Supreme Court would step in relatively quickly, which for a case like this probably means the end of the year, the beginning of next year.
Well, Phil, this has been incredibly helpful, incredibly interesting. Um, any final thoughts for our audience?
No, I would just say this, that I think that, one of the things that I think it was useful for us to have this conversation is because I think sometimes people know that Harvard's on a terrific winning streak right now, and they've got a good judge. And so some folks may be wondering why Harvard is thinking about settling. And there's lots of reasons why Harvard might settle, but certainly I think people ought to be aware of the fact that there may be bumps down the road for Harvard in this litigation.
Yeah, there's always uncertainty in litigation, and there's expense and there's time. So it's always settlement, very often a good option. So thank you, Phil. And thank you all for watching. And we will continue to monitor this litigation as it unfolds, and we will report to you as it develops. Thank you very much. Thank you, Phil.
Thanks to you.